Activists have gone to court to challenge the Computer Misuse and Cybercrimes Act of 2025, saying it violates the Constitution by curtailing free speech. Former Chief Justice David Maraga has also criticized President William Ruto, describing the signing of 8 bills into law last week as unconstitutional and the new law as draconian. NTV's Laban Shaban reports on the implications of the new digital legislation.
On October 15, 2025, President William Ruto assented to a series of pivotal bills that are set to reshape Kenya's legal and digital landscape. Among the most discussed is the Computer Misuse and Cybercrimes Amendment Act of 2025, which introduces significant changes to the regulation of online conduct. Rights activists have filed a case at Milimani Law Courts under certificate of urgency, challenging the new digital law. Petitioners argue that it violates fundamental rights guaranteed by the Constitution. The case will pit the Kenya Human Rights Commission and Reuben Kigame with 4 others against the Attorney General and the Speaker of the National Assembly. The President also signed into law several other key pieces of legislation: Privatization Bill, National Land Commission Bill, Land Amendment Bill, Virtual Asset Service Providers Bill, Air Passenger Service Charge Bill, Wildlife Conservation and Management Bill, National Police Service Commission Bill. One of the most debated provisions of the CMCA of 2025 is the expansion of Section 27 on cyber harassment. Under the 2018 Act, Section 27 made it an offense for a person who willfully communicates with another person if the conduct is likely to cause fear, apprehension, or property damage, detrimentally affects the person, or is indecent or grossly offensive and affects the person. The 2025 amendment expands this to include messages or statements that are likely to cause someone to commit suicide. A person who commits an offense under this section is liable, on conviction, to a fine not exceeding 20 million shillings or to imprisonment for a term not exceeding 10 years or both. This penalty came into force in 2018. The petitioners challenge amendment to this section, describing it as ambiguous and unworkably speculative. Former Chief Justice David Maraga has faulted the President over the approval of the disputed bills.
The amendments to the Computer Misuse and Cybercrimes Act, in essence, seek to control and crush political dissent and protests in the guise of protections from cybercrime.
At the same time, the 2025 law introduces Section 46A, giving courts clear powers to order the removal or shutdown of online content, websites, or digital devices used in criminal activity. When a person is convicted of promoting unlawful activities, child exploitation, terrorism, or religious extremism and cultism using a computer, website, or digital device, the court may remove the content or materials, close or deactivate the system, website, or device, or issue other orders it considers necessary. The law also allows authorized persons, such as law enforcement officers or cybersecurity experts, to approach the court if they suspect a system or site is being misused. The court can then order the removal of content, shutdown of devices or systems, or other measures necessary to prevent harm. Under the Computer Misuse and Cybercrimes Act of 2018, Section 30 dealt with offenses related to sending harmful or threatening messages, focusing mainly on messages sent through digital or electronic platforms such as text messages or online communication. The 2025 amendment broadens the scope of the provision by explicitly including emails and phone calls alongside messages.
It is also worth noting that there was limited public participation in the passage of the bills, with only 3 written memoranda, with all signatories opposed to the amendments.
The new digital law, along with 7 other bills, has sparked uproar among online activists and is expected to be gazetted by the Attorney General 14 days after President William Ruto assented to them last week. Laban Shaban, NTV.